I'm Mark Fernandez, and this is Franchising with Fernandez.
Hi, good morning and welcome. My name is Mark Fernandez, and for those of you who don't know me, I'm the director of BDA. We do everything franchising. Welcome to our third webcast on Australian franchising and the coronavirus. Today, we are here to answer your questions and give you an update on what's been happening in our sector. We'll start with our standard disclaimer that this is not legal advice. This is a general discussion on a broader level. And if you need any more specific advice, we suggest you contact your professional advisors. All right, a little bit of housekeeping. For all your questions will be moderated by myself. So to the right, you will find your group chat box. So please start sending through your messages and we will get the panelists to answer them one by one. We'll endeavor to get to as many as we can, and if we can't, we'll certainly email you out the questions. All right, so without further ado, let me introduce our panelists. From Hodgkin Hanley Lawyers, we have partner Carolyn Megan joining us. Carolyn has a considerable commercial litigation experience and prides herself in supporting her practice with an understanding of commercial reality, thereby achieving her clients' desired outcomes. Her focus is on property, contract, employment, and estate litigation, no matter how complex. Carolyn appears regularly in the Supreme District Court, as well in various tribunals in and throughout Western Australia. Welcome, Carolyn.
Thank you. Good morning.
Dean McCaskill, BDA's retail property consultant. Dean has nearly 30 years experience in shopping centre and retail property management, marketing, and the leasing industry in Western Australia and throughout Australia. Welcome, Dean McCaskill.
Oh, thank you, Mark.
And to talk all things accounting, John Dorazio, Managing Director of Walker Wayland WA. John's experience and skills include providing audit and consultancy services to entities in a range of industries. He has a keen interest in transport businesses, franchises, health industries, sporting organisations, and is always willing to meet with business owners or organisations that need help improving systems and performance. Welcome, John.
Thanks, Mark.
Great. And I'll be talking strategy and giving you an update on what's been going on. All right, let's talk about what we know is happening out there in franchising space around the world. Through some conversations with my friends in the US, we believe that the main concerns revolve around leasing. We understand that franchisees are a little bit scared, so they're getting together in groups and collectives, gathering as much information as they can to work with their franchisors to put together packages of relief with their landlords. And it doesn't really matter which way and who owns the leases, if it's the franchisor that owns the leases or the franchisee that owns the leases. There's lots of clarity around who is doing what. So it's lots of communication. So it's really about information, and the key between everyone is everyone's talking. In our friends and partners in the UK, we know that franchising has been massively impacted. The closures around the shopping centre malls and high traffic areas have decimated some franchise systems, and we believe that some businesses may not reopen, and some systems between 100 and 300 units may not open again. They're constantly talking with their supply chains. We believe that there's pressures around supply chains, getting products and services in and out of the UK. And it's just a friendly reminder for all that they remain positive and they're all working shoulder to shoulder. And the words I hear from our UK friends is everyone in franchising is putting their arm around each other and saying, hey, how you going, mate? Can we help you? So franchising spreading throughout the land. In Australia, we're in what we would call a holding pattern. We're waiting for more information on the big ticket items. So for instance, leasing, and Dean will talk about the government initiatives that were released yesterday. The accounting, as far as the Mark 1, 2, and 3 stimulus packages, employees, what to do with them. So we're in a holding pattern. What we do know is that franchise businesses are starting to roll their sleeves up now and finally get the message and put their arm around franchisees, showing some empathy and also working with them on changing their business model. However, on the flip side, we're still hearing and seeing that franchise field service and operational teams continue to be released from their roles. This is a huge concern, not only to the franchisees, but to the longevity and sustainability of the brand in the views of the franchisees and also their customers. All right, let's throw to John. John, can you please bring us up to date on what's been happening in the accounting world, the packages, and answer the question, I guess, is what do I have to do to get the money and when can I see it? Over to you, John.
Yeah. Good questions, Mark. Before I get onto that, I think I might just update everyone just to let them know that the government has changed the working from home tax deduction. So that's a good little change that came in and probably slipped under the radar to some degree. So taxpayers working from home may now claim a rate of 80 cents per hour from working from home. So I guess that's up from the old 50 cents or whatever it was previously. So that's a nice little bit there for people now working from home. In terms of, yeah, it's a good little one. In terms of the JobKeeper and the timing of money, you don't really have to do anything. And this is probably where the government's single touch payroll kicked into effect last year and even earlier for some other businesses. If you're on that system and using it, then you don't really have to do anything. The next time you lodge your BAS is when that will sort of work itself out. If you've registered for the JobKeeper with the ATO, it should automatically just happen for you. In some instances, the ATO might want additional information, but essentially the first payment will kick in May. So you shouldn't have to do too much more for that. If you aren't using single touch payroll, then you're going to have to go through a manual claim process. And I have absolutely no idea how long that's going to take to get your money. So hopefully everyone's using the single touch payroll and it can just work away on the online claim system. So it shouldn't take too much effort from anyone to get that money. It will be paid monthly in arrears. So don't forget that you've got to fund effectively the first month being April before you really get any money coming through. Right. The other thing to keep an eye on is if you're in a new business or you've just started out, there is discretion there for the Commissioner to actually still allow you to be eligible for the JobKeeper. So just because you've got a new business or you just started doesn't mean that you're not going to be eligible for it, because that was one of the things that I'd been fielding quite a lot over the last couple of weeks was people and clients that have gone into business for the first time, have only started trading since January onwards, and they're going, we're not eligible, but the government's come out and said, yes, you are. There is Commissioner discretion there to allow that to happen. And it's the same for lumpy businesses as well, where you might have income sporadically throughout the year. So you're allowed to use some alternative tests in that regard. Yeah, I think that's probably about it in terms of the JobKeeper. I mean, there's obviously, I think we've talked about in the past, you know, casuals, as long as they've been employed with you for more than 12 months, they're eligible. If they're part-time and full-time, then they're eligible. And if you've got an employee that works for multiple businesses, then you need to make sure that that it's their primary employer who they need to nominate will be eligible for that JobKeeper. Talks about family trusts being eligible for it. So if you're running your business through a family trust and you don't necessarily get a wage, then you can also be eligible for the JobKeeper payment. And that goes back to private companies as well, where you might just get dividends. But in that case, you need to nominate one shareholder and one director are eligible for that. So a couple of little quirks there, I guess, just to be aware of. It's obviously applicable to sole traders as well. So I don't know if you've got any other questions, Mark, but
Yes, we've just had one come in, and it relates to the $750 stimulus package funding again. And I know we answered this last week, but I think we should touch on it again. And the question reads, if my employee is working and collecting the $750 a week on an average, but some weeks dips down below that, am I still able to claim the full amount?
well, I'm not. You are allowed to claim the full amount. That's fine. They have to be paid a minimum of $1,500 a fortnight. So that can be averaged out if you're a monthly employer. As long as they get paid monthly and it averages out at that $1,500 a fortnight, then there's no problem. So if you're receiving the JobKeeper payment, then you must pass on at least $1,500 a fortnight before tax.
Great. I think we might hold the other couple of questions till a little bit later. Wonderful. Thank you, John, for that update. Dean, if I can get you to talk through the current understanding of what was released yesterday by the federal government, and what does it mean for us in franchise space?
Well, it's actually quite interesting. My main complaint is the same as many other commentators, is the principles behind what they're trying to do with commercial leases appear sound, but what's lacking is the detail. Look, in simple terms, what the government is trying to achieve is that businesses that are directly affected by either shutdowns or essentially just a drop in turnover will be able to claim or a waiver of rent pro rata the reduction in turnover. So quite simply, for most people, that's going to be, for example, pulling up your turnover figures for March 2019, comparing them to the turnover figures of March 2020. And then, and here's the key point, coming to an agreement with your landlord. A couple of things about the federal government's announcement yesterday is the federal government can't legislate in this area. It's a state responsibility, so we're relying on state governments to introduce legislation. I'm hoping that legislation will be identical in each state, but I doubt it. Each state has different retail tenancy legislation, so that means, and from a legal point of view, I imagine it's problematic. You can't use cookie-cutter legislation across the states to achieve the same outcome. But at the end of the day, you're still going to have to negotiate with your landlord. I doubt that when the detail of the legislation is published, that it's going to acquit us of that responsibility. So it's the deal with the landlord that's going. The devil is always in the detail. My main caution to clients at the moment is I've seen a couple of landlords get on the front foot and put deeds of waiver deeds of variation in front of their tenants, promising to defer rent. The best example I can find is a shopping centre in Perth, which had sent around deeds of variation to each of their tenants, offering to waive or defer rent for 6 months. Effectively, that word deferral means that the rent will be paid, but later, or by extending. The difficulty with that is you're creating a debt. Now, if you have a retail business, you're a franchisee, you're carrying debt from the purchase. It's going to be very difficult to sign up to an agreement that's going to incur more debt, which is essentially what a rent deferral is. So most people will fasten on the word waiver, which is correct. My preferred arrangement that I have achieved with a few landlords in the last few days is to waive rent for a period of time. We actually don't know what that is, so it's almost indefinite. And then to extend the lease term by the amount of time that the rent was waived. Again, another difficulty with that is I expect market rents to drop dramatically over the next 6 months to 12 months through the rest of calendar 2020. So you might find yourself there having extended the lease by 6 or 7 months, still paying well and truly over the odds. But of course, you can renegotiate that at the end of the lease term. So I suppose none of that is particularly helpful, except for the fact that it's going to come back to negotiating with your landlord. If you read any of the literature published by the federal government, and it's very scant, by the way, we're mostly dealing with media reports of what the Prime Minister has said rather than legislation that's been published, you'll see that it keeps coming back to negotiating an outcome. So that's going to be problematic. I have urged all my clients that where they can, get on the front foot, open your books to the landlord. This is another very important point, that there is a natural tendency amongst independent business people to confidentiality and being reluctant to share their performance figures with third parties, including landlords. In this case, we have no choice. So I have been operating on an open book with almost all the counterparties I'm dealing with, which is a complete sales history. And in fact, I've been putting in front of people P&Ls going back 3 years so that people can understand how business performs during what we would call normal, and trying to come to an agreement that way. So I am hopeful that legislation will be passed by state governments, but I do not think you should rely on it. I think you must take the front foot and approach your landlord as soon as possible. The bigger landlords, the large institutions, have already put in place systems to deal with these sorts of requests. And I have to say that the major institutional landlords or retail property landlords in Australia have mostly been reasonable. So what I mean by that is I've not seen any evidence of rent demands from shopping centres or retail landlords, apart from a few small independents. And any requests for rent are usually accompanied by a request for performance information. And so, for example, yesterday I was privy to a whole raft of letters from landlords to tenants asking for their sales figures for March 2019 so they can compare it to March 2020. So that's where it's at. So really, the legislation that may be passed by the state parliament will help, but the onus is still going to be on you as the lessee and proprietor of this franchise business to go out there and deal with your landlord. Again, where franchisors are holding leases, obviously it's a little bit easier for them. They have a common entity across their properties. But in many cases, franchisees are actually holding leases directly. And so the onus is on them to deal with their landlord. I know that's not really a great deal of help at this point in time, but there is light at the end of the tunnel. I see the intent from the federal government and the state government is good, but I don't think it's going to be smooth sailing. In these sorts of situations, there is no cookie cutter solution. There are just too many factors that make each lease transaction different, depending, on the ability of the landlord to finance a 6 months rent waiver, for example. But it's the right intent. So let's see how that all plays out, but get on the front foot. That's my advice.
Thank you, Dean. And what we're hearing is around the traps are franchisees are trying to get on the front foot and deal with these things, but they're scared. They don't know how and what to do. So this is a time for leadership from the franchisor and or specialists. But what we also understand from what you're saying is to be transparent, be open and take charge, acknowledge that, we are in tough times and keep the communication lines open, and where you can, don't just simply ignore it. It's going to come.
No, that's correct. You must take some action, and that's usually what by take some action I mean communicate. And it's more than a phone call. I think we need to start creating records of these conversations and discussions with landlords, because we don't quite know what the enforcement provisions of the legislation will be when and if it's eventually published.
Yes, and Dean, just a final one there on extensions of leases, where we're hearing, the opportunity to waive 3 months, but add it on to the term So effectively, if you've got a 5-year lease with 2 years to go, you've got 2 years and 3 months. We spoke a little bit about this last week, where that's not easily done, and franchisees need to get some advice because there could be an issue extending your franchise agreement. So,
oh, that's right. We've got all of the complications that go with property tenure, which is, how does that sync up with your franchise agreement? I mean, everything is much more complicated than it would appear at first, but it's still possible to navigate your way through it.
Awesome. Okay, we've got a couple of questions, but we'll leave that till after Carolyn's update. Carolyn, simply put, how do I keep my good staff? Should I let them go? I'm struggling. What do I do? And, am I allowed to, just let people go?
Well, look, unfortunately, there's no simple answer to that, because it depends on each individual circumstance, whether the employer falls under the federal system or the state system. But the most recent update in terms of employment law has been there are rolling through changes to the modern awards that apply to different employees. And again, each situation is different because each employee will fall under a different award. But the modern awards, so for example, the ones that have already been amended as at the end of March include, understandably, the Restaurant Industry Award and the Hospitality Industry General Award. So just as an example, with the Hospitality Industry General Award, they've made amendments which allow employers to direct employees to perform work which is outside of the scope of their normal role, within reason. Obviously, if you're a shop attendant, you can't be asked to get on the other end of a welder or anything like that. But
I've seen it. Don't trust me. I've seen it.
I wouldn't like to see myself in that position, I tell you. But the other thing is that they've also included provisions whereby employers can reduce the average hours of full-time employees. This is again under the Hospitality Industry Award as an example. Obviously, we all know it used to be 38 hours a week, and they're saying anywhere averaging between 22.8 and 38 hours. You can now do that lawfully without it amounting to what we call a repudiation of the employment agreement. And similarly with part-time employees, as long as they're working between 60 to 100% of their usual guaranteed hours, you're not breaching the employment agreement. There are requirements to consult about these sorts of changes. The other thing that they're bringing into play with these amendments to these modern awards is the ability for the employer to direct an employee to take annual leave if they have annual leave available, and you have to give them 24 hours notice under the Hospitality Award. And there's also provisions, quite sensibly, that the employer-employee can agree to take, that the employee takes twice as much annual leave, but they get paid at half the usual rate. So that's how things are being dealt with in the employee space, at least initially, is to make these changes to the various modern awards, which will give employers and employees a bit more flexibility to change their arrangements. So that was a long answer to your request for a short answer, but I think the short answer is, as we've said before, to the extent you're able, like we've been saying with the leasing, keep your staff on if it's possible. There's now some flexibility around that. You need to keep your good people, because when this all blows over, those are the people you're going to need to rely on to get your big business up and running again. So that's a bit of an outline of the most recent updates in the employment space.
Great. And I've got one question here. It's come in regarding traineeships and apprenticeships. Has there been any similar reliefs put around hours and discontinuing traineeships?
Not as far as I'm aware as yet. It may be in the pipeline, because they're amending, it's about 103 different awards and other arrangements. So It may well be in the pipeline. It's going to be a process because each change has to go through the process of the Fair Work Commission actually making a decision as to whether proposed amendments should be made. So it also relies on the industry bodies, the unions, actually making applications to the Commission for these sorts of changes. So it's probably in the pipeline, but I haven't seen any updates in that respect. Mind you, I haven't had to look directly at that issue myself as yet, but I certainly haven't seen anything.
Okay, wonderful. Well, let's go to a couple of questions now, and thank you very much for that, Carolyn. This one, John, I think is for you. Are franchisees not specifically listed on their respective payroll eligible for the JobKeeper payments, assuming the restaurant is deemed eligible?
The simple answer is yes, they will be eligible, but it really depends on the structure or the legal entity structure that they've got. So depending whether they're a company, there's certain rules around companies and how they get treated. Like I said a bit earlier, if it is a private company and you don't get paid anything other than wages, other than dividends, or you're taking drawings or something of that nature, then only one director will be eligible for the JobKeeper payment. And then there's also one shareholder will be able. So if it's husband and wife, I believe that both would still be able to access the JobKeeper payment. If it's a family trust, the same sort of rules apply. So I don't believe there would be a problem with both of them claiming it, where they've both been beneficiaries of the trust previously.
Okay, here's another one for you, John.
Actually, it actually does say, sorry, just to cut you off there, Mark. It says here, trusts can receive the JobKeeper payment. Where beneficiaries of a trust only receive distributions rather than being paid salaries and wages, one individual beneficiary can be nominated to receive the JobKeeper payment.
Okay, wonderful. Thank you, John. Here's another one for you, and it says not necessarily regarding franchise accounting, more around business advice. Can you advise or point us in the direction of what other services or platforms that we should be looking at in our own businesses moving forward?
Look, I think from a business perspective, there's a number of things that business owners should be doing now. With the JobKeeper payment and the other government incentives out there, it's really important that people plan and do some three-way forecasting. I think that's critical that they do that. The other thing to keep in mind is, as people are working from home now, and I've noticed that there's a lot of gyms and those sort of businesses that have all now gone to running online classes. You know, digital security is something that they all need to consider. So making sure that you've got the appropriate controls in place around how you protect yourself is important. You know, if you've got people working from home, you want to make sure that your IP is protected. And I think that's something that every business owner should be looking at as well.
Great. Wonderful. Thank you for that, John. Dean, got a question in here for you regarding, and I know we touched on this last week and you may choose to defer it, but regarding residential tenancies and my own rent. Is there any structures in place for the government funding on my personal rental as a tenant?
No, again, I think residential is certainly not my area, but I think the same caveats apply to residential tenancies as apply to commercial tenancies. The government is asking for the parties to attempt to negotiate a resolution between themselves. And so really it's going to be up to the individual. It does not appear to be any mechanism by which they're going to implement, I don't know, national or statewide legislation. So again, I think it's getting on the front foot. Like retail tenancies, individual residential tenancies are all very different. The circumstances of the landlords are very different. The circumstances of the tenants are very different. So it's going to be up to the individual. I think there is a moratorium on evictions, but I don't think you get away with paying no rent. You have to again demonstrate what the direct relationship relationship is between your employment or your income or your business and your ability to pay rent. So again, it's got to be open book, but not really my area, residential, but sort of the same issues apply.
Sure. Great. And Carolyn, here's one for you on a legal franchising battle. Is the ACCC, are you aware if the ACCC is making any inroads to franchise arrangements, given that we're under pressure now and we have to, under the franchising code, give notice during the standard and applicable periods for extensions to franchise arrangements? Wow, great question.
The ACCC obviously is a regulatory body, so their response is more likely than not to come at a later date, because it'll be a response around if there is an issue with or an allegation that a franchisor has been acting in contravention of the code, and more particularly, it's probably likely to be the famous good faith provisions of the code. Then that is ordinarily when the ACCC would step in and determine whether it would investigate further and take any steps to enforce the provisions of the code, or indeed the Competition and Consumer Act, which requires everyone in business to act conscionably. So, I mean, what we're going to find, I think, in the long term is some interesting developments, which don't necessarily help the listeners in the short term, but some interesting legal developments around these concepts of good faith, unconscionability, misleading and deceptive conduct. But these things haven't yet sort of come through the system, so to speak, as far as ACCC is concerned. And as we've said, and Dean has mentioned, they don't really help people in the short term, because the ACCC in particular is more of a regulatory body, so it's a responsive, it's responsive rather than proactive. I hope that answers the question. If there's any aspects of it, not having the question in front of me, if there's any aspects of it I've missed, I'm happy to go through.
All good. Right, we're slowly running out of time here, so we'll just go around and get your top tip. John, if we can get your top tip for the week in a minute or so, what would it be?
Definitely register for the ATO's JobKeeper payment. Even if you think you might not be eligible, still register, because you never know if you're going to need it. So
great.
Get on.
Dean? Top tip?
Sorry, I was muted there.
Sorry, Dean, your top tip in less than a minute.
Yep. Okay. Start communicating with counterparties to your lease. Get it in writing, even if that response is a refusal from the landlord. At least put it in writing. Create a record that you've made an effort to resolve the problem. Wonderful.
And Carolyn?
I'm going to step in on the lease debate too and agree with Dean. You need to get things in writing. You need to be very mindful of any deeds of variations to your lease, and make sure that you engage with your franchisor about the consequences of any variations to your lease, to your relationship with the franchisor, or it may amount to a breach of your franchise agreement, etc., and lining up your franchise agreement with your lease. And in terms of employees, keep an eye on the Fair Work Commission website as they roll through the changes to the modern awards. Get some advice about where you stand as an employer or an employee, and which awards may or may not apply to your situation, so that you can keep abreast of the changes, because they're not across the board changes.
Great. Wonderful. Well, I'd like to thank the panel, John, Carolyn and Dean, for your time. And if you need any assistance, please email me at mark@bda-online.com.au and we'll endeavour to answer your questions. Remember, tomorrow we have our next webcast with special guest Carolyn Megan on navigating employees in difficult times, which is at 10 a.m. Western Standard Time. So thank you, Carolyn, for your time. So I hope you can join us next week as we continue these weekly updates on Australian franchising and the coronavirus. I'm Mark Fernandez, and on behalf of the panel, I thank you for attending, and we wish you all a safe and healthy week. Bye for now. Thank you, panel.
Thanks, Mark.
Thank you. Bye.
Thanks, Mark.
I'm Mark Fernandez, and this is Franchising with Fernandez.